A very warm welcome to Min's studio. Today we have with us the Deputy Chief of Bureau, Mr. C.H. Unnikrishnan, who will tell us about the very contentious issue of compulsory licensing, a practice in which a country can override a patent of a drug maker to provide greater access to the public for a medicine. Welcome to the show, Unni. Thanks so much for joining us. Could you tell us what is the latest in this tussle on compulsory licensing? What does the US government want in its agenda?
Yes, Buma, as you know, US government has been trying their level best to influence India and even other developing countries as far as the patent enforcement of patent law is concerned. And even earlier we had issues like US government or US officials engaging Indian officials concerned with the decisions in IPR enforcement, as well as even including IPAB decisions. Earlier, US Secretary himself had sent a letter to the Commerce Ministry of India to have a favorable decision in one of the IPAB cases in regard to patent challenge. Now, in this case, under the guise of educating Indian officials or Indian department concerned on the enforcement of proper IP law or appropriate way of enforcing IPR in the country, US is saying that the US Director of US Patent Office has openly admitted that they have put people on the ground level in Delhi to have dialogues with the Indian officials concerned with the decisions of granting compulsory licensing. So, but anyway, the domestic industry hasn't taken this in a light manner. They have already written to the Ministry of External Affairs and has asked whether it is legal to have a foreign government trying to influence the policy decisions or a judiciary procedure in India.
Assuming the US government is able to hold some sway, is able to influence the governments in developing countries to fulfill this agenda, what do you think will be the outcome? What will be the impact on Indian patients as well as Indian drug makers?
Ideally, it shouldn't happen, not only in India, in any other developing countries, because a compulsory licensing is a provision which is allowed by WTO under the TRIPS Act to prioritize the country specific needs, especially in the case of pharmaceuticals. It is the suffering patients who suffer when there is a shortage or a lack of access for emergency medicines. Here, the compulsory licensing, which was first granted in India in February, was in consideration of severe shortage of a patented drug, which is for critical cancer, by which Government of India decided to compulsorily license the patented technology to a local drug maker, wherein the patients ultimately benefited by getting the product, getting the drug at a much cheaper cost compared to the patent holder's price.
That's all we have for you in here. Thank you so much for joining us. We'll keep you updated on the latest in this chapter between patent versus public access to medicine tussle. It's been going on, it will go on. It's a long drawn battle and we will keep you posted on what happens in this. Thank you.